Good morning. This is Gina Clowes, National Director of Training and Outreach for FARE, Food Allergy Research and Education. I'm here today talking with a friend and really a rock star in the allergy community, attorney Mary Vargas. Mary is a partner at Stein and Vargas LLP, a civil rights law firm that focuses on impact litigation to ensure equal access for individuals with disabilities. Mary's won critical victories in disability discrimination litigation and has a special interest in food allergy law. Thanks for being here, Mary.
Good morning. I'm happy to be here.
And we're happy also to talk with you today and also to let folks know that you'll be one of our guest speakers at our conference, FARECon, in November later this year. So we're excited to have you back again. You've been one of our most popular speakers. So for those who don't know you, would you share a little bit about yourself in regards to food allergies on a personal level?
Well, sure. I was a disability rights attorney before it became personal. I have 3 boys, and the youngest of my 3 boys, Perry, has food allergies. He's allergic to peanuts and tree nuts and shellfish. And I started seeing disability rights through his eyes the first time he tried to go to a summer camp and I was told that he needed to leave his EpiPen with me, and I needed to wait in the parking lot. And all of a sudden, all the work that I did professionally in disability rights became personal in that moment, and I've gotten to see what inclusion means through his eyes.
Mm-hmm. Can you explain, or would you explain, excuse me, a little bit about impact litigation? What does that mean?
Sure. Impact litigation is a kind of litigation where you pick and choose the cases that will establish the foundation or critical victories in a movement. It's not litigating every case that comes through the door. It's not filing a lawsuit every time somebody breaks the law. It's looking at the issues that are most important to a community and choosing the parts of those issues that can be won, and filing those cases in a way that builds a foundation for the community to stand on going forward.
Okay, and we talked before that SP versus City of Pallandale might be a good example of a recent case that's an impact case. Can you share with our listeners about that case?
Sure. So this case involved a little girl who was in kindergarten at an elementary school in California. She had a 504 plan for food allergies, and her EpiPens were kept in the nurse's office. Her mother had gotten a new job and needed childcare for this little girl and her twin brother so that she could go to work. And the city recreation department offered, as many recreation programs do, an aftercare program that it was right at the elementary school this child attended. So she would have been able to stay at this program and go right from school right into aftercare without her parents having to come in and transport her somewhere else. Unfortunately, despite repeated requests and attempts at education, the aftercare program refused to provide this child with access to epinephrine. So the aftercare program went until 5 or 6 o'clock. The school nurse's office closed at around 3. And so although this child had epinephrine in the nurse's office, once that door was locked between the hours of 3 and, say, 6 o'clock every day when she would have been in this program, there would have been no access to epinephrine. Her parents proposed multiple ways that it could work, that she could self-carry, that the program could carry the epinephrine, that they could put it in some kind of locked box. And the program said, no access to epinephrine. We'll simply call 911 if there's an emergency or an allergic reaction. So we filed suit in federal court, and a public settlement resulted, which I think was really positive, not only for this family, but for their community and for the food allergy community at large. The program agreed to train their staff in food allergies and administration of epinephrine. They agreed to take responsibility for keeping epinephrine in the program and making sure kids had access to it when they needed it. And they also paid a fairly substantial monetary component that was $118,000 in the
Wow.
settlement. And they, this is my favorite part of the settlement, they also agreed to bring food allergy singer Kyle Dine into the schools and pay for him to provide a concert for the entire community to learn about food allergies and to benefit from what could have been a negative experience. It turned it into something that was positive and something that was empowering for this child who actually wants to be a songwriter. So for her to get to meet Kyle and to have him talk about her world of food allergies with her peers is a really positive outcome from a negative experience.
I mean, that, first of all, it gives me the chills. Second of all, I absolutely love Caldine. I love that they had to train the staff. I mean, every pin was knocked down. They had to train staff. They had to provide access to epinephrine, $118,000 settlement. Like, you need to take this seriously. And then the icing on the cake, and more than that, is just having Kyle there, especially since she had an interest in that. It's absolutely heartwarming. I mean, kudos to you, Mary. So even though this family came up against major roadblocks, they had to know in their hearts that they were in the right. This aftercare program fund center needed to accommodate what's considered a disability. Why did you take this case, though? What did the parents do right that kind of set you up, that you knew this was something that you could or that you would choose to pursue?
One of the things that's really important is when parents interact with the world on behalf of their children with food allergies, that they present as calm and reasonable and not focused on litigation. The family that's focused on litigation, that's not a family we're going to represent. We're interested in the family that's interested in working the problem out, that's trying at every turn to avoid litigation, that's trying to educate, that's really focused on fixing the problem. And when that fails, that's when we're interested in stepping in.
Yeah, I'm trying to approach it from a lot of what is the harm in just focusing right out? You know, you read a lot of things, and I admit, you know, in the past I was thinking, you know, just escalate things. When you have trouble, just escalate. What's the problem with that approach?
You can't fight everybody. As the parent of a kid with food allergies, there's probably something every week that happens that that gets, you know, it could get my blood pressure going, and that's not a good way to live, and it's not helpful, and it's not a good example, I think, for a child. How we advocate for our children teaches them in turn how they advocate for themselves, and picking and choosing battles is, I personally think, a much healthier way to live than having a fight with everybody.
Right. And we live in a world, they largely do not understand food allergies. And so, you know, if every single time you're escalating or you're spending your life being angry, it makes it really difficult. I've taught my son, even on a personal level early on, there are some people, even relatives who love you dearly, who don't understand. And that's a lot easier way to go through life than to being mad because so-and-so doesn't get it or can't cook safe food for you.
Right. I mean, you want kids to feel like there's a lot of good in the world, and there are lots of people who help them, and sometimes the people who don't, they just don't understand. And the point, this is going to sound weird, but for me, the point of litigation is to make the world better. If you're suing just because you're angry, that doesn't make the world better.
Yeah, and I think the case you just mentioned, I mean, what an important case to have for parents, and I hope that they use cases like this and the Young Shakespeare's case and other cases that you've litigated just to show, because now you have these in your back pocket to say, because a lot of it is, it's just ignorance and not, you know, I tell parents cluelessness is not necessarily maliciousness. They just don't, they don't know what they don't know, but you know, holy smokes, a case like this with all of these things, training staff, epi access, a huge monetary settlement, and Kyle Dine, this is, you know, we've hit all the bases here to really show that this was the wrong way to handle this. You need to accommodate this.
Well, you have to give credit to the people who agreed to do this. That there are folks who, when you file a complaint against them, they respond in a fairly ugly way. And then there are folks who say, how do we fix this? Right? And those are the people you hope you find, where you can work together to fix the problem, make the world better. And that's particularly important where there are children involved, because children as plaintiffs is a whole different ballpark.
Mhm. Can you say, I know, like, for example, the case with young Shakespeare, and, you've been very involved with Mason's family, and it's had quite an impact on them. And we had talked a little bit about, you showed me the perspective where the family almost didn't have a choice. Can you say more about that?
Sure. So Mason is a pretty amazing kid, and he was denied access to Shakespeare program, a nonprofit organization in his community that he had hoped to join with his friends and peers because of his food allergy. And, looking back now from the perspective of, well, the United States Department of Justice issued a letter of finding, which is a really big deal, saying that this program discriminated on the basis of disability and acted with coercion and manipulation towards children. That's a hugely positive result. It's something I probably hear maybe once a month from somebody who contacts me to say, I used that letter of finding to get access to this program or that program. And so it has this hugely positive impact for other people. But for the child in question, being the one who is excluded has a cost. Standing up for your rights has a cost. And the question is it better for that child to stand up and say, I had a right to access, and I have a right to access, and this was discrimination, and fight back, or is it better to say nothing? And that's very much a personal decision, but I can say that, for a child like Mason, there's cost either way. Had he not filed a complaint, it wouldn't have changed the fact that he wasn't able to do something that all of his peers could do, and that teaches a child about who they are and what rights they have and their role in the world, just the same way that filing a complaint and saying what happened to me isn't right does. So there's benefits and costs each way, and with something like the young Shakespeare players, there's, I think, a huge benefit to the folks who come after them, who can use that letter of finding to get access for their children in other programs and to educate other programs not to do what this program did. But it does come at a personal cost. For me, it's not unlike medical research. When you participate in a clinical trial, you may not see that benefit. You are doing it on the faith and on the value that you are improving the world for somebody else. And litigation can be very much like that because there may not be a tangible benefit to you or your child.
Did you see the movie Lorenzo's Oil?
Yes.
It reminds me of that movie.
Exactly
I mean,
that.
I just was bawling through that movie, and I forget which parent said this was Lorenzo's Oil watch the movie. It's a very good movie, and the boy is very sick, and the parents are just dedicated to finding a treatment, and it was almost too late for their son, and they said, we're going to continue on because this is for other kids. So, yes, Mason and Sam, what they have been through, no child should spend those precious years of their life going through the stress and strain that their families had to endure. But we're very grateful for the work that you and their families did to make a difference.
They're complete heroes. I think there are two kinds of people in the world for me. They're the people who rush into the burning building, and they're the people who stand and watch. And Mason and his family and Sam, they are the people who rush into the building and help, and that's just how they're wired. But they have paid a price for that has benefited all of us.
Yes,
and I guess that's part of the other thing that's sometimes hard for me is sometimes I do see in the food allergy community that, particularly in online communities, that when these cases are filed, people sometimes are quick to criticize, why did you eat at that restaurant, or why didn't you do this, why didn't you advocate in this way, or why would you even put your child in a program that didn't want them in the first place? And those kind of comments they're damaging personally to the people who filed the complaints, who are part of our community, and they see that. So they're not only taking fire from everybody else, they're taking friendly fire, which hurts more. But it's also very damaging when the community is not united around a message of inclusion and equality sort of the dignity of every child and their right to participate and do what other kids do. When people tear that down and question it publicly, it's damaging. And those cracks in our community can be used against us very effectively when defendants say, well, lots of people wouldn't have done what you did, and there are people who say this or that in your community. It does have a cost.
I couldn't agree with you more. I think that it's just so important when a child or an adult is advocating for their rights, especially for parents listening who may have really young children, and you can do almost everything yourselves to protect your child, but as they get older, they have every right to access and engage with the world. And to criticize someone, a preteen or a teen or an adult because, we don't eat out, or we don't go to camp, or we don't fly, or we homeschool, there is a point where your child is going to become an older child and a teen and an adult and need to engage with the world, and some level of accommodation in all these areas is needed. So
yeah, I so agree. I remember when my son was first diagnosed when he was just before he was 3, and that first year when he had 2 anaphylactic reactions. I couldn't have imagined him going to a sleepover. I couldn't have imagined him going to a camp. There are a lot of things that he does now that we, of course, prepare for and plan around, but that he does because it's really important to him to be independent, and he needs to be out in the world like everybody else. But it's very hard to understand that from that place when you're newly diagnosed and scared, and you have a child that's so young and so easy. Well, it's not really ever easy, but that you can insulate them. You can not have them go to the party and they might not know any better, or you can have them not do a club and they might not know any better, but when they get older they do know, and it shapes who they are, and they want to be like other kids. And in my opinion, I think they should have that opportunity.
Yes, I mean all those things from 0 to 3 that you think never, no sleepover, no dating, no. And then I remember my son's first sleepover. I forget how old he was, 10 or I don't know. I just remember it was like a movie marathon for me. I was sitting there just like I just couldn't sleep. But I was determined to. I mean, I brought like 3 garbage bags full. Here's all his food for he could have lived there for 2 months. They were like, what? Here's my entire medicine cabinet. We're going to train you here. They thought I was crazy, but he in the next one was a little bit easier, and that was just 2 garbage bags. But yeah, they want to engage, and we want that for them. But it is hard. Yeah,
it really is, and it's hard to know what that looks and feels like. It's hard to know what it's like to be a parent of a 15-year-old when you have a 3-year-old who's just been diagnosed.
Yes. And so you've been doing amazing work over the years, and we're so lucky to have you in our community. And I want to ask you a question. It's a Dan Sullivan question. He's a business coach. But if we were having this discussion 3 years from today, and you were looking back over the last 3 years, what has happened in our community, or for you professionally in the allergy community, for you to feel happy with our progress?
Wow, that's a tough question. What I hope we see in the courts, for sure, because that's what I do. I hope we see a number of cases recognizing without a lot of difficulty that things like food allergies and celiac as well, and other disabilities that impact what a person eats and how they interact culturally with the world. I hope we have court decisions that recognize that these are disabilities, so we can stop talking about whether somebody deserves to be included, and we can start talking about how to include them. I think we're on the verge of that. The law changed a few years ago, so we're really just starting to see these cases now getting through the court system. We're starting to have court written decisions on what it means to be a person with a food allergy and whether that entitles you to protection under federal law. I really hope 3 years from now that's just sort of accepted, so we can kind of move past that ridiculous debate about whether a person deserves to be included and really start talking about how to make the world more equal.
So it's not if they deserve to be accommodated, it's how do we do that in all these different situations. I love that, Mary.
Right.
Okay,
right.
I love it. So with that in mind, I just want to remind everyone listening that Mary is going to be one of our guest speakers at FARECon, our conference this fall. And if you wouldn't mind leaving us, knowing what you know now, what is one thing that you would like everyone to know? What is one piece of advice that you'd give anyone dealing with food allergies that you'd like them to know about managing food allergies or managing an individual or a child with food allergies?
Pick your battles. It's a marathon, not a sprint, and it's not healthy or feasible to fight everybody that you're going to encounter who's going to have misperceptions about food allergies and what rights people with food allergies have, and to the extent possible to try and educate, and litigate only as a last resort.
I love that. Yeah. There's no individual or organization who is going to get it 100%.
That's right.
Well, Mary, it's been a pleasure, as always, talking with you. Thank you so much for sharing your thoughts today, and we look forward to hearing more from you in November.
Thank you. I can't wait for November.
Okay. Have a great day then. Thank you.
You too. Bye-bye.
Bye-bye.